straight ahead on Law and Crime Daily. A fugitive on the run. The national manhunt for Brian Laundrie, but no charges yet in the death of Gabby Petito.
The odds are, the overwhelming odds are, that she was killed by someone she knows.
Plus,
there's no evidence.
The jury heads to deliberation in the federal case against R. Kelly. Then trial begins for the Mennonite murder.
This defendant, Mark Gooch, kidnapped and murdered Sasha Krause.
We bring you up to speed on the case of a former U.S. airman accused of killing a young teacher. And later, Derrick Chauvin pushing back on his murder conviction in the death of George Floyd. How the ex-cop requests an appeal to his conviction. Law and Crime Daily, covering court cases from coast to coast. Welcome to Law and Crime Daily. I'm Simon Chowdhury in for Brian Buckmeyer along with Terry Austin. Now we begin with a nationwide manhunt. Brian Laundrie is officially a wanted man. An arrest warrant is now out for Laundrie after a grand jury indicted him in connection to the death of Gabby Petito. And Jeanette Levy is here with the details of the charge Laundrie faces.
Brian Laundrie faces one federal charge of unauthorized use of access devices. Specifically, the FBI says that Laundrie used Gabby Petito's debit card and PIN.
The indictment says Laundrie used the Capital One debit card from August 30th to September 1st and obtained things of value of $1,000 or more. That would have been 3 days after a family's GoPro recorded what appeared to be Gabby Petito's van in the Sprague Creek dispersed camping area of the Bridger Teton National Forest. Petito's body was found in that area on Sunday. The coroner said Petito's death is a homicide, and the FBI says Laundrie is a person of interest. Forensic death investigator Joseph Scott Morgan spoke about the arrest warrant.
When the feds issued this warrant, was that they set in motion to put him in direct sights of the feds as a fugitive. And now they've unleashed the power of the U.S. Marshal Service. And U.S. Marshal Service specializes in hunting people and tracking them down and bringing them in. And that's what's going to happen now.
FBI Special Agent in Charge Michael Schneider issued a statement saying, while this arrest warrant allows law enforcement to arrest Mr. Laundrie, the FBI and our partners across the country continue to investigate the facts and circumstances of Ms. Petito's homicide. We urge individuals with knowledge of Mr. Laundrie's role in this matter or his current whereabouts to contact the FBI.
Brian Laundrie's attorney issued a statement saying it's his understanding that this charge is related to events that occurred after Gabby Petito's death and not her actual demise. Steve Bertolino went on to say that the charge and the allegations contained in it will be addressed in the proper forum after the FBI locates Brian Laundrie. For Law and Crime Daily, I'm Jeanette Levy.
All right, thanks, Anjanette, for that report. Meantime, authorities, they continue the manhunt for Laundrie in a Florida reserve. He was last seen Tuesday. Now, the search began for him last Friday. Reports now say he left his family home without his cell phone or wallet. His parents say they're concerned he may hurt himself. All this comes after an ill-fated cross-country road trip. Petito was last seen alive near Grand Teton National Park in Wyoming. Laundrie returned to his family's home in Florida without Petito driving her van. A funeral is scheduled for Petito near her family home in New York on Sunday. Let's bring in co-host Terry Austin and legal analyst Dina Dahl. Now, Dina, I want to start with you. If Brian Laundrie is found, can we expect federal charges, being that Gabby Petito's body was found in a national park, which is federal land?
It is true that if a murder is committed on federal land, then federal charges are brought. We don't know yet, though, if she was actually killed in the national park or if it was just her body was disposed there. So we will, as they do more of the investigation, they have ruled it, the coroner's ruled it a homicide, but they haven't yet revealed, where maybe she was killed. So that's a little bit unclear still. As we know, the federal, they already have a federal arrest warrant for him. So it's possible if he is caught that there may be a federal murder charge brought for him also.
And Terry, social media is circulating a theory that someone can commit murder in the zone of death and not be prosecuted. Is that true? And explain what this is.
Absolutely not true. This zone of death means that under the Sixth Amendment, frankly, you have the right to be prosecuted for criminal charges in the same state and district. Apparently, the federal district is in Wyoming, but it's in the state of Idaho where this zone is. But as Dina just mentioned, under federal law, under Title 18 USC, you can basically bring a federal charge against anyone because it occurs on federal property. And this is Yellowstone, it's federal property. There's no question you cannot get away with murder anywhere in the United States. Usually it's going to be by the state. In this case, it would be by the federal government.
Yeah, and for even more coverage on the Gabby Petito case, of course, everyone is paying attention to this. Listen to the Law and Crime podcast, Cocktails and Cocktails. This week, host Sergeant Sean Sticks Larkin sits down with retired homicide detective Danny Smith, who gives us his take on Brian Laundrie's involvement in her death.
But the point is, everything is pointing toward this boyfriend. And as an investigator, you always want to stay in the middle of the road. You don't want to come to conclusions, but you do want to say, well, I used to say it like this. It's not that I'm investigating him as a suspect, but I have to exclude him as a suspect because just from the circumstances, he is going to be on a list of people that I'm going to consider a suspect, and I need to exclude him. And if you work really hard to exclude someone who turns out to be guilty, you're really you end up building a really good case, you know?
And you can listen to Cocktails and Cocktails on Apple Podcasts or wherever podcasts can be found. Well, still ahead on Law and Crime Daily, opening statements in a Mennonite murder case. What can we expect from Arizona versus Mark Gooch? But first, closing arguments are over in the federal trial of R. Kelly. When can we expect a verdict in the singer's trial? All this and more coming up next.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTube TV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTube TV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTube TV. We put you in the jury box.
Welcome back to Law and Crime Daily. The jury is out in the federal trial of R. Kelly. Kelly faces a multitude of charges, including racketeering and sex trafficking. Most of his sexual accusations included women who were under the age of 18 at the time. Over 5 weeks of testimony, 45 witnesses and 11 accusers spoke out against the R&B singer, explaining their experience with his alleged abuse. Disturbing testimonies included how the singer would lock girls in a room with no food or water, force them to have sex with him, and that the singer knowingly transmitted herpes. The defense called 5 witnesses, most of whom were former employees of Kelly. Their testimonies often contained contradictions. And as closing arguments wrapped on Friday, Kelly's lawyer said, quote, "So he became a sex symbol. Where is the crime in that?"
Do you think your closing argument was effective?
That's up for the jury to discern.
What do you think the main point you want them to walk away from that was?
There's no evidence.
Let's bring back Terry and Dina. Terry, we're learning that the jury has requested the testimony of Jane Doe number 3. What do you think this means?
You know, Simon, I think it means they want to hear that testimony from the beginning to the end. She was a little unusual. She went to interview Kelly, actually never got the interview. She said she was locked in a room, that she was starved. When she finally did get some food, she felt drugged. She woke up, he was standing over her. She felt some wet between her legs, so she knew something had happened. She said she didn't say anything about it because she was afraid and he threatened her. So the jury is probably thinking she's different from the rest. She didn't go there to be with R. Kelly, wondering maybe why she didn't report it, but probably trying to focus on what that threat was. And that's a very important part of this RICO charge.
You know, let's backpedal a minute. Dina, on Thursday, R. Kelly's defense team compared him to Martin Luther King Jr. And then on Friday, they referred to him as a sex symbol. This is unconventional, to say the least, when you're wrapping closing arguments. What do you make of this?
I mean, I think he went too far for sure. I imagine he turned off a lot of jurors by comparing him to Martin Luther King. But I think he did a better job when he compared him to Hugh Hefner and, you know, those kind of things, because he was trying to say that just because you may not agree with the way he conducted his life, that does not make him a criminal. And that is true. The problem is that the prosecution has a lot of evidence toward the fact that he also was committing crimes. And the other thing the defense attorney said was just that all the witnesses were liars. And prior bad act witnesses were allowed in, and they are allowed in sexual assault cases in order to bolster the credibility of witnesses. This is why, because the only way a defense attorney can poke holes is to say that the witnesses were lying. The more witnesses saying the same thing, it's much harder to make that argument.
All right, let's switch coasts now and head to California in the federal trial of Elizabeth Holmes. Former Theranos employees testify saying Holmes knowingly moved forward with a Walgreens product rollout despite performance issues. On Thursday, the 8-year veteran of the company testified she quit after concerns about the company's capabilities. The scientist said under oath that Holmes knew her blood testing product was ill-equipped, but moved forward with the plan involving the pharmacy store anyway. Holmes faces 12 counts of fraud for her time with the now defunct Theranos. The Stanford dropout claimed the company would revolutionize blood testing, but later investigations found many problems with those tests. If convicted, Holmes faces up to 20 years in prison. She has pleaded not guilty, and testimony will continue next Tuesday when court resumes for the case. Well, we have an update for an alleged murder that took place decades ago. Almost 45 years after her death, the so-called Escapa Jane Doe, supposedly the victim of a serial killer, has been identified. Mississippi authorities identified the woman as Clara Birdlong, whose skeletal remains were found on the side of a highway in 1977. The now deceased convicted serial killer, Samuel Little, confessed to killing 93 women, including the Escapa Jane Doe. DNA evidence helped investigators uncover the victim's identity in December of 2020, just 1 month after Little's death. Little was known for knocking out his victims with punches and then strangling them. Right now, Clara Birdlong's cause of death is still unknown. Well, coming up on Law and Crime Daily, Derrick Chauvin, no money and no representation, asking for an appeal on his guilty conviction. That's coming up next. And plus, we have opening statements in the trial of the former airman accused of murdering a Mennonite school teacher. We go inside the Arizona courtroom next. And welcome back to Law and Crime Daily. Witness testimony is underway in the trial of a United States airman accused of murdering a Mennonite woman. Prosecutors say 22-year-old Mark Gooch kidnapped and murdered 27-year-old Sasha Kraus back in January of 2020. Now, he's pleaded not guilty to the charges of first-degree murder, kidnapping, and theft. Kraus was last seen shopping for Sunday school supplies near her Mennonite community in New Mexico. About a month later, her body was found near Flagstaff, Arizona. And at the time, Gooch was stationed at Luke Air Force Base in Phoenix. An autopsy revealed Kraus died of blunt force trauma and a gunshot wound to the head. A crime lab reported that the bullet taken from Kraus's skull was fired from a gun that Gooch had in his possession. Cell phone records put Gooch in the area at the suspected time of the crime, and a previous text message, several text messages from the defendant showed disdain towards the Mennonite community. In court on Friday, the prosecution claimed Gooch sought out a Mennonite woman and took great lengths to cover up the alleged crime by hiding a murder weapon and cleaning the car he kidnapped her in.
The defendant contacted a friend and asked this friend to hold some personal items for him. One of those items being a .22 caliber rifle, unbeknownst to the friend. And then the defendant went and got his car professionally detailed to the tune of $220.
Let's check in once again with co-host Terry Austin and legal analyst Dina Dahl. Dina, in a case like this that presents unconventional issues and that the victim was a Mennonite woman, would that in any way affect the witnesses called or the trial in general?
I mean, I think that the prosecutor will probably explain, what Mennonite is, because most people may not know, and there may be some sort of stereotype or something with that. It is both a religion and also seen as an ethnic group. And also, actually, they're pacifists. So they might also go to motivation. Here is this violent crime allegedly committed against a Mennonite woman because he did not like the church, which was a pacifist. So we will probably see them, the prosecution, tie that all in, help educate the jurors as to, what the religion is and how the religion can play into the motive.
And Terry, based on the prosecution's opening statement, it sounds like there is substantial evidence against the defendant. Do you agree?
I do agree. I think there is a ton of circumstantial evidence. There may not be any direct evidence. And the defense attorney actually mentioned there are no witnesses, so you won't see that type of direct evidence. But they do have his travel records as far as his phone is concerned. He's admitted, frankly, that he went from Glendale to Farmington. So that's not really an issue. We saw that he did computer searches, according to the prosecution, for the missing woman herself. He cleaned his car. I think the biggest point here, though, is that .22 caliber rifle that he hid with his friend. And the forensic says that it's the same type of bullet. So I think they have him on that circumstantial evidence.
All right, well, we have to take a quick break. But when we come back, Derrick Chauvin appeals his conviction on his own behalf. What comes next for the former officer who killed George Floyd? Welcome back to Law and Crime Daily. A Kentucky man charged with murder enters an Alford plea deal in connection to the shooting of Calvin Q. Taylor. The 70-year-old victim was found dead in his Kentucky home in October of last year. Neighbors reported hearing gunshots early that morning, and Taylor was pronounced dead at the scene. Anthony Manning and his mother, Lorena, were near the scene during the crime. Anthony claims he didn't enter the home until after he heard the gunshots. The mother and son are charged with murder and first-degree robbery. In a hearing on Monday, Anthony Manning entered an Alford plea deal, a guilty plea where the defendant maintains his innocence but acknowledges there is likely enough evidence to result in a conviction should the case go to trial. Now to Minnesota, Derrick Chauvin appealing his conviction in the death of George Floyd. The former Minneapolis police officer was charged with the murder and manslaughter of Floyd after kneeling on his neck for over 9 minutes. He was sentenced in April to more than 20 years in prison. The former cop is now appealing the conviction on his own behalf to the Minnesota State Supreme Court after he was denied a public defender. The appeal cites 14 issues, including the judge's denial to sequester the jury and change the venue of the trial after public outrage in the Minneapolis area. The 45-year-old says in his appeal that he is out of money and without representation and is asking the court to put his appeal process on hold until his denial for a public defender has been reviewed. All right, so Dina, why would Chauvin have been denied a public defender?
So as we know, his attorney was paid for by his police union during the trial. But once there was a conviction, they no longer would pay for a lawyer for his appeal. So he did try to request a public defender. You are only eligible for a public defender if you can show that both your liquid assets and your current income are so low that you could not afford your own attorney. So the determination was made that he could actually afford an attorney, and it was denied. This, like you said, he is appealing it. Interestingly, the judge, Cahill, initially also approved a request by Chauvin for pauper status, which would mean he wouldn't have to pay any court filings. That was reversed today. So there is some, again, in that case, he must have found that he had enough income to be able to pay these court filings. So it's unclear whether or not Chauvin will be able to prove that he is eligible based on the finances to get a public defender.
And let's talk about the appeal. Terry, what do you think about the grounds of appeal that Chauvin outlined?
I actually think he did a great job outlining the different areas. It was everything in the kitchen sink, and I think many of the areas he outlined will not be successful. So prosecutorial misconduct, that's not going to succeed, I don't think. I think some of the appeal grounds, like jury misconduct, also will not succeed. But there were a couple of grounds there where I thought he had a chance. Sequestering the jury might have been a big issue. Change of venue would not have been a big issue. Whether or not they let in that evidentiary evidence as far as the May 2019 incident was concerned, the defense wanted the whole part of that in, and only some part of it was in, not the entire part. So I think that might be a good ground. And then finally, I think as far as that third-degree murder charge was concerned, that was a huge issue. That could be one of the grounds that he could succeed as far as the appeal is concerned.
So you think he did a good job outlining it, but you don't think the chances of him winning his appeals is a good chance?
He did a great job outlining it, but most of the grounds are not going to succeed. He has a decent chance of winning one.
All right. Thank you so much, ladies. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice here in America.